Hi, everyone. Welcome. Thank you so much for joining us today. We're going to go ahead and get started with our presentation. Today, we have an overview of anti-lobbying regulations for federally funded scientists. Just a couple of housekeeping items to get us started. There's a chat box in your controls, and you can use that at any time. We recommend that whenever you have a question, you just go ahead and write it in the chat box, and then we'll address the questions at the end. We're going to leave plenty of time for those questions, so whatever you might have, we should be able to address it. We also want to let you know that the webinar is being recorded and will be archived online. With that, I'm going to introduce our two speakers today, Lauren Kurtz and Augusta Wilson. Lauren Kurtz is the Executive Director of the Climate Science Legal Defense Fund. Prior to joining CSLDF, Lauren was a litigation associate at Dechert LLP. Lauren has a JD and a master's in environmental policy from the University of Pennsylvania. Augusta Wilson is a staff attorney at CSLDF. Before joining them, Augusta was a fellow at NYU Law School's Gargiani Center in Environmental, Energy, Land Use Law, and a staff attorney at the Clean Air Council. She received her JD from Cornell Law School and BA in biochemistry from Case Western Reserve University. And the Climate Science Legal Defense Fund is a nonprofit organization that provides free legal advice and representations to climate and other scientists who have legal issues as a result of their work. CSLDF also works to educate researchers on their legal rights and responsibilities. And to introduce myself, I'm Elizabeth Landau. I'm the Assistant Director of Public Affairs at AGU, and I will be moderating today. I just wanted to give a little overview of the partnership that AGU and CSLDF have had. In recent years, we've seen an increasing number of scientists who found themselves involved in legal discussions about their work, correspondence, and also public statements. So we want to help better prepare the scientific community for these challenges. And AGU and CSLDF have joined together for the past 7 years to create a legal education for scientists program, which includes webinars, events at our fall meeting, and online resources for scientists. I wanted to highlight a couple of events that we're having at this year's AGU Fall Meeting. This includes 2 workshops, one on how to get involved in the rulemaking process, and another in Science in Court, Becoming an Expert Witness in Climate Litigation. And we're also offering one-on-one within attorney sessions where you can sign up for a time slot to speak privately with a CSLDF attorney. These are 30-minute consultations where you can ask any legal questions regarding your scientific work. You can find these on the Fall Meeting website. If you go to fallmeeting.agu.org and under the Audiences tab, click on Science Policy, you'll find all this information. And with that, I'm going to go ahead and turn it over to Augusta and to Lauren.
Thanks, Liz. This is Lauren. As was just said, I'm the Executive Director of the Climate Science Legal Defense Fund. We were started 7 years ago, as Liz suggested. We actually were first begun as a PayPal page to crowdfund for the defense of scientists who found themselves under legal attack. I'll just say, researchers who've unfortunately found themselves targeted as a result of their work, find themselves under fire, and we help defend researchers from these sorts of onslaughts. We've also really tried to help researchers not get into these sorts of issues. We've had a few researchers at various points over the past few years, try to get involved in political advocacy and activism. The vast majority of the time, there's no issue, but on occasion, if you receive federal money, it is possible to get tripped up. Certainly, it can be a thing where you haven't actually done anything wrong, but it is possible for some opponent to make it look as though you've done something wrong. So we're going to talk today about, first of all, what is lobbying? What does that involve? What is permissible? What is not permissible? And what you can do to make the most sure that, what you're doing will not get you into trouble or get you into anything that could look like you should get into trouble. So with that, I'll just start with saying, lobbying is defined as attempting to influence a politician or public official to create particular legislation or conduct a particular activity in a way that will benefit a particular organization. So what does that mean exactly? It means, for example, if you work for a health insurance company and you have representatives from the health insurance companies try and meet with Congress people to discuss various ways that healthcare reform should happen, presumably that would benefit the health insurance company. It does not mean someone who works for a health insurance company who personally has an opinion on gun rights and who calls up the representative in their own time to talk about their personal opinion on something that's totally unrelated to their job. So we'll just start with that right now. If you're, for example, a climate scientist and you called, your congressperson in the last month or two to talk about your preferences regarding a Supreme Court vote, that would not even be considered as lobbying. So that in and of itself is totally fine. The Anti-Lobbying Act itself is designed to prevent individuals and organizations from using government funds towards lobbying. So lobbying is totally permissible. You need to be a registered lobbyist if you're engaged in it, and you cannot be using government funds to further the lobbying. This is pretty sensible if you think about it. Really, what the government does not want to be doing is giving people grants so that they can then buy themselves train and plane tickets to go back to Congress to ask for more money. So that's the core of it. If you can steer away from that, you should be fine. And we'll talk a little bit more about the nuances of what that is involved. I'm going to start off actually with an example related to a federal employee, because this was in the news in the past year. We're focusing today on federal grantees, but I think it illustrates the example of how sometimes it is worth being extra careful, because even if you haven't done anything wrong, there are folks out there who can try and make it look as though perhaps you have done something wrong. So in this situation, Dr. Linda Birnbaum, who is the director of the National Institute for Environmental Health Sciences, she wrote a piece or co-authored a piece that was published in Science magazine. And in the piece, she talked about how in the last few decades, it's become clear that perhaps some of the regulations relating to toxic chemicals and pesticides, et cetera, are outdated and are based on science that has since been updated to reflect that these chemicals are perhaps much more dangerous than earlier thought. And at the end of the piece, she put something to the effect of, it would help if citizens worked with government to ensure that we have better policies. And Lamar Smith, who is a representative from Texas, he's been called anti-science by a number of folk, and he accused Linda Birnbaum of violating anti-lobbying laws because he alleged that by putting the sentence in her piece, urging citizens to work with lawmakers, that she was violating anti-lobbying laws. I'll start off by saying that she was, in my opinion, she was not violating anti-lobbying laws, and the investigation he called for has apparently gone nowhere. Certainly a number of people, including other representatives in Congress, spoke out against it, but it was an unpleasant experience, I'm sure, a lot of heartburn having to defend herself. And the reason that he was able to at least create some, allegation, even as flimsy as it was, is because in the case of federal employees, really the main thing that they're not allowed to do is use their federal position to encourage grassroots efforts. The idea being that, someone at EPA shouldn't be able to use the EPA Facebook account or Facebook or Twitter account, whatever, to urge the public to vote, urge the public to ask their congresspeople to vote a specific way that would benefit EPA. So that's sort of like a little funky thing as it relates to federal employees. The rules as they relate to federal grantees, people who receive government money, also including contractors, people who have like a contractual arrangement but aren't employees, they are in some ways simpler. They're a little broader also, but it's still, we hope, should be pretty easy to avoid any trouble, and we will explain how. So I'm going to turn it over to Augusta now.
Great, thanks. I'll pick up where Lauren has left off here. And as she's describing, So there's this general principle that federally appropriated funds that have gone, for example, to an agency like EPA or NIH or whatever other similar organization shouldn't be used for lobbying. And that has sort of gotten extended, particularly through a piece of legislation that's commonly known as the Byrd Amendment, as you see here, to grants, contracts, and loans, also cooperative agreements that involve federal money. And it makes a lot of sense. If an agency couldn't itself use federal funds to engage in lobbying, the principle is you don't want the agency being able to get around that by simply hiring somebody else to do that, using that same money that they shouldn't be able to use for lobbying. The sort of potentially apocryphal tale about how this came about was that Senator Byrd found himself meeting with a lobbyist who was employed by a group that had received federal grant money. And that lobbyist was being paid with that grant money to come meet with Senator Byrd to try to get more money. And he found that pretty infuriating, according to this tale. And so he introduced this piece of legislation which made it illegal to do that. So yeah, the language is fairly straightforward. Recipients of federal grants, contracts, loans are prohibited from using those funds to attempt to influence a member of Congress in relation to awarding a federal contract, grant, loan, or extending an existing federal contract, grant, or loan, or increasing an existing federal contract, grant, or loan. And I'll note very quickly, although this gets a little bit more complicated, but it is worth being aware of that, at least in some cases, there are other federal regulations, not the Byrd Amendment itself, but other regulations that extend some of those same principles to lobbying state legislators. So not just members of the U.S. Congress, but state legislators as well. So if you are interacting with state legislators, do take some care to make sure that you're taking note of what the applicable rules are. So, you know, we've often said before, we talk to people and we talk to scientists about these rules, and I think there is a tendency for us to really scare people and make them feel like they cannot, ever send another email again, or they're going to get in huge amounts of trouble. So I really want to dive into this here by explaining that although there are these regulations and laws in place, there's really a fairly wide range of activity, even specifically lobbying activity, that it is in fact completely fine for a scientist who receives federal funding to undertake. So that's what I'm going to focus on here. And there are sort of a few different categories, and we also had earlier, and we have some materials that we're working on addressing federally employed scientists, so scientists who work directly for a federal agency. Here, we're focusing on folks who one way or another are not federally employed, but are receiving federal funds. So first up is if you are a scientist who works at a state or local agency that receives federal funding, there actually you have an awful lot of latitude in terms of how you can engage in activities that basically are lobbying. There's really a pretty broad recognition that scientists who work for executive agencies, either at the federal or state or local level, those agencies have recognized executive legislative relationships and are often very directly involved in policymaking and working with legislators. And so for the most part, that is completely fine. You in your professional capacity can work on policy issues and interact with legislators on those issues. So next, if you are a scientist who works at a university or a nonprofit organization that receives federal funding, you too can generally interact with members of Congress in quite a number of ways in your professional capacity. So scientists at organizations like that, at research institutions and nonprofits that do research using federal funding, can go give to a member of Congress a technical or factual presentation on a topic that directly relates to the performance of their federally funded work. If the member of Congress who represents the grantee has requested such a presentation, and this is something that actually does happen. Legislators are working on an issue, or they're considering appropriations, and they want to hear from you about what you've been doing, and that is completely fine. You also can provide to a member of Congress or other official nonpartisan analysis, studies, research. So anything that doesn't actually relate specifically to action on a particular bill, for example, something that's nonpartisan in nature, is going to be fine. You also can engage in discussions with officials about broad social, economic, and other similar problems. Generally, as long as you're not dealing in that case with a topic that's specifically related to your work and to your funding, if you're talking more about general issues, that's going to be just fine, even if they haven't specifically requested that you come. And finally, here you see that you also can, it sort of goes back to what I was saying at the beginning, but maybe a little bit broader in that it can be a congressperson or other federal official requesting technical advice on some issue, maybe that's not specifically what you're working on, but some related issue. And that too is completely fine. If they've requested a presentation, you can go ahead and give it and not worry that you're going to run into trouble with anti-lobbying laws. So to take a little bit of a step back here and talk more broadly about, what can you do both in your professional capacity and even bigger than that, what can you do in your non-professional capacity, in your private life as a citizen, if you are interested in engaging in, different forms of activism and advocacy. So, as we've been saying, you certainly can meet with a legislator to discuss general policy issues or nonpartisan analysis. And you also, in your private capacity, are free to engage in lots of other kinds of advocacy on social or economic issues that you care about. So you can attend a demonstration, write an op-ed, or sign a petition, or engage in any number of other, sort of forms of activism on issues that you care about. And I want to note finally here that you can meet with a legislator and engage in activities that really might, absolutely meet the definition of lobbying as a federally funded scientist, as long as you are not using federal funds to do that. So, the general rule of thumb is if you are acting on your own time and using your own resources, you're on pretty safe ground. So we sort of put together a list of best practice do's and don'ts, things that, even stepping slightly outside of the lobbying context, will be very helpful to scientists in trying to minimize the possibility of any sort of negative repercussions on you in your professional life should you care to engage in activism on issues of the day that you care about. So the sort of best practices do's here are be sure to use your own funds and resources to engage in advocacy and to do it on your own time. That's going to be the safest approach. We really highly recommend doing what you can to keep your email and social media accounts separate. And by that I mean try to draw a clear line between your professional email account and any professional social media accounts you may have or use and your private accounts. So trying not to conduct work business, on your private email. If you want to send out, for example, a tweet about some political issue of the day, your best bet is going to be for sure to do that from your private account, not from any account that's affiliated with your employer. And similarly, to make it a practice to use your personal devices, computers, phones, tablets, whatever other electronic devices, if you are engaging in online advocacy of some kind, emailing about getting a protest together, for example, or about signing a petition, whatever the case might be. If you want to, for example, as I was sort of referencing earlier, send out a tweet or write an open letter, just as a couple examples, you should probably consider doing that clearly in your own personal capacity and making that explicit. And sort of tied in with that, when you're engaging in those kinds of activities, consider not mentioning or using your professional title and affiliation, and that will help you keep a clearer line and ensure that it is clear that you are acting and speaking as a private citizen and not on behalf of your employer. And another suggested do here is to consider using different kinds of disclaimers. If you, for example, want to sign a petition or write a letter or put out some kind of statement. So, for example, we've seen situations where people want to sign an open letter and it's requested that they have their title and affiliation included with their signature. If you are going to do that, consider ensuring that there's a disclaimer that title and affiliation are for identification purposes only. Another example of some helpful disclaimer language, these are my personal views, not those of my organization. These two will help ensure that it's clear that you're acting in a private capacity and minimize the likelihood of any problems for you at work. And finally, we would just recommend that everybody who is considering engaging in these kinds of advocacy activities just take some time to make sure they understand the policies that their employer has about political speech and speaking to the press, and make sure that you are acting within them. So the list of don'ts here, and a lot of these will be sort of reiterations of what we've already talked about, but the biggest don't is do not use federal funds to directly lobby members of Congress or state legislators in favor or in opposition to a specific piece of legislation. That is going to be the clearest way to actually run afoul of the anti-lobbying laws in this case. And similarly, don't use federal funds to do indirect or grassroots lobbying. So as Lauren, I think, was sort of mentioning this, one of the places that some of the agencies like EPA, just as an example, but there are others, have run into trouble is grassroots lobbying. And by that I mean using social media or mass emails to encourage members of the public to support a particular rule or a piece of legislation. So you may run into trouble if you use federal funds to undertake some kind of media campaign like that. Sort of those are considered grassroots campaigns, or they have been. So avoid using any federal funds to undertake something like that. Also, do not use federal funds to advocate for a continuation or an increase in your or your organization's federal funding. That too is going to run pretty directly into the language of the Byrd Amendment. And as we've sort of been talking about, recommended don't muddle your personal and professional roles. So a couple other examples, if you want to attend a protest, we would highly recommend not wearing clothing with your organization's name or logo or other identifiers. And similarly, if you want to meet with a legislator, we would highly recommend under most circumstances, unless you're really clearly doing it in your professional role and that has been approved by your employer, not to wear clothing that identifies your employer. So a couple of quick, just hypothetical examples that may be helpful for thinking about how these rules sort of play out. So supposing that you are a federal scientist, a scientist who receives a federal grant, and you are in D.C. for a meeting at the NIH, and you want to meet with your senator while you're there to discuss next year's budget. Can you do that without running into trouble with the anti-lobbying laws? And the answer is yes, you can, as long as you meet with your senator either before or after the meeting at NIH, and that you don't miss any part of your scheduled NIH meeting activities to do it. And finally, as long as going to the meeting with your senator doesn't cause additional federal expense. So you're not using federal funding to pay for an extra night's hotel, for example, or for a car. As long as you avoid using any federal funds or time to take that meeting, it is fine.
It's also true that you can meet with your senator in a situation like this for any personal reason. So the reason that possibly gets you into a gray zone is because it's about your NIH-related budget. But you could certainly use the time at the meeting to talk generally about science funding, to talk about an issue unrelated, gun rights or healthcare bills or whatnot. But just when it gets close to what federal funding relates to do, that's when you have to start getting more careful.
Right. Yeah, absolutely. So one more just hypothetical example here to help us think through this. Imagining that you are a federally funded scientist and you would like to send a tweet to your followers on Twitter encouraging them to call their senators to express their opposition to some particular bill that you care about. Can you do that? So here, and this actually ties, sort of as another example of what Lauren is mentioning. So a lot of the answer hinges on whether the bill at issue relates directly to your federally funded work or not. If it does, and especially if it involves continued or increased funding for that work, we would probably recommend that you not do that. Because you could potentially run into some arguments that you are engaging in a grassroots campaign. If the bill at issue is not related to your federally funded work, then it's probably okay. But we would still advise as sort of general best practices to make sure that you send a message like that from your personal account, not your employer's, that you do it on your personal time and on your personal device. That's the sort of most protective thing. That's the best way to ensure that you cannot run into any trouble. So we have here at the end just we wanted to mention that CSLDF has quite a number of resources available on our website on a range of issues that we encourage you to go check out, and we hope that they are helpful. A whole different range of issues that scientists encounter regularly, and this is our contact information. If after the session today you have any questions, please do not hesitate to call or email. And I think, Lauren, you had some things you would like to mention as well.
So as Augusta says, you can call or email us at any time. We are both confidential and free, so please feel free to take advantage of our availability and let us know if you have any legal issues related to your work, or I hope this isn't the case, but if you actually are encountering any legal issues, please give us a call. Once or twice a year, scientists will get every year we have scientists who've gotten a letter from a congressperson or who've gotten a threatening sorry. If you're getting threatened with a defamation lawsuit or you're getting targeted by a member of Congress, please reach out. But also, feel free to contact us if you're having any questions or you want to understand how to better protect yourself. As Liz mentioned, we will also be at AGU. If you have questions, you can feel free to come to our one-on-one with an attorney service. You can email the email address there, lkurtz@csldf.org or awilson@csldf.org, and we will put you in the calendar. We're there from Monday through Thursday at AGU. We also have 2 events, as Liz also mentioned, one on how to participate in the rulemaking process and the notice and comment process, which sort of dovetails with what we've been talking about here, how not to violate anti-lobbying rules. But if you want more directly to get involved in the rulemaking process, we have a session from 11:30 to 12:30 on Tuesday. And then on Thursday from 12:30 to 1:30, we have a session on science in court, where we'll be discussing some of what's been going on in the climate litigation space and talking to scientists who might be interested in at some point serving as expert witnesses and helping them understand what that involves. So that's our AGU programming. So please, if you're interested in these topics, come find us. And with that, I will open it up to questions if anyone has any.
Great. Thank you so much, Lauren and Augusta. That was wonderful. We do have a few questions, so I will go ahead and start asking them. If anyone else has questions, please feel free to ask them in either the question box or the chat box. You can send a private chat to just the organizers if you'd like, if you don't want everyone to see your question, or use the questions section, either way. And I just want to note that the webinar is being recorded and will be available online. So if you missed this or if you want to share it with colleagues, if you missed any particular part or want to share with colleagues, you certainly can. So the first question that we have is, does the Hatch Act cover advocating on behalf of science policy?
I think, and please feel free to chime in here, but I think if you're referring to generally, for example, saying we should have stronger environmental laws or some other similar sort of broad principle relating to science policy, the answer would be no. The Hatch Act pertains pretty specifically to political activities. And Lauren, please feel free to chime in if you have further.
Yeah, we have actually some materials on the Hatch Act, and unfortunately I don't have it in front of me. But Augusta's right. The Hatch Act really is mostly about financial aspects, and there's some wacky things in it, like federal employees can't run for city council. But general things should be fine. The person with that question can email us and we can give you a more specific answer to that. But in general, the broader issues are fine. It's doing things like taking a clipboard to work and circulating it and asking your colleagues to commit to vote for a specific candidate.
Right. Or running in an election or saying I support a particular party. It's tied to pretty explicitly partisan things. And the other thing that's worth mentioning is that the Hatch Act covers federal employees and to some extent actually state employees too, who are in programs that receive federal funding, but would not, to the best of my knowledge, cover, for example, a scientist who was employed by a nonprofit or by a research institution that just received federal funding.
Yes, that's right. It only applies to employees, not grant recipients.
Great, thank you for that. The next question is, it's common for scientific paper discussions to conclude with suggestions and or calls for future research in a particular area of research. Given that the science is published with federal funds, is this allowed?
I think a call for general research should be totally fine. And I don't have the exact sentence in front of me, but the reason that Linda Birnbaum got into trouble is because she encouraged citizens to contact lawmakers, which, again, I think that was a misuse. of the prohibition, and I don't think Lamar Smith was justified in accusing her of anti-lobbying. I brought it up as an example of just to be aware that this has happened. The true thing that you cannot do is end your presentation, your federally funded presentation, and tell people to call their congressperson to vote yes or no on a specific bill. That is what gets you into trouble. A general request for research funding should be totally fine. Linda Birnbaum got a little closer to the prohibition by asking people to just contact their legislatures in general for better legislation, which is fine. It got her in a little bit of hot water because, one, Lamar Smith is not a nice person, and two, she was getting closer to the prohibition, which asks you not to seek grassroots supports for specific legislation.
Thank you. The next question is, at what point would CSLDF services not be free? If the legal battle gets more intense or a court resolution is needed, are services still free?
Yes. We have always been free. We get foundation and individual donations to be free. Similar to much larger groups like the ACLU, it is important from us on principle not to charge people for these services. There are situations where we can't help people, more because it's a topic area that we can't assist on. For example, if you're having an employment dispute with your institution, depending on the facts, that may actually not be something that we can quite help with. But in general, please contact us. When in doubt, contact us. And worst case scenario, if it's not something that's totally in our wheelhouse, we'll try to find you another group that can help.
Thank you. The next question is, Lauren mentioned being a registered lobbyist. Who needs to register? I don't if I'm just calling my legislator once in a while, right?
Oh, no, definitely not. A registered lobbyist is like, for example, someone who works full-time for Philip Morris and their entire job is meeting people on the Hill to try and get them to do certain things. I mentioned that just because I wanted to explain that lobbying in and of itself is not the problem. Certainly if you're doing things to the point of being an actual lobbyist and you're not registered, but if you have a day job and you're doing if you're doing these sorts of things, the amount of work that you have to actually do that falls under lobbying to need to register is pretty high. It gets to the point of you're doing a full-time job and just not appropriately registered. The issue really for federally funded scientists is doing the lobbying of the sorts that would get you into trouble by violating anti-lobbying regulations. But a call here and there to your senator, an email here or there is totally fine. It's if you're spending, 25 hours a week on this, then you have a problem.
Thank you. The next question is, I see a lot of my friends and colleagues who have disclaimer language in a personal Twitter profile that says, quote, all opinions my own. Do you recommend including this in our social media profiles generally?
I think it can be helpful. It depends what you're tweeting about, but if you're getting into a situation where your employer might start to find it, something that they wouldn't vouch for as the employer, it's not unwise. We have had researchers get into trouble because they didn't use disclaimers, and the effect was, or could be argued, the effect was that it looked like they were speaking on behalf of their institution. But that really only gets you into trouble if you're doing things like, in one situation, for example, they all wrote an open letter and they signed it with their names and titles. And the kerfuffle was that they didn't really have the institutional support to sign this open letter. If you're using social media to share like New York Times articles, I think it's less important. But if you're doing more politically active things, it's not a bad idea at all.
Mm-hmm. And I guess I would add one thing that would make me inclined to say falls more into the category of not a bad idea at all is if your Twitter account, although it's your private account, has your institution listed, which I think often people do. If you want to do that, then having, I would say particularly then, a disclaimer saying opinions my own or something to that effect is not a bad plan.
Yeah, I would agree with that. It's really, if you're in a situation where someone could make a reasonable claim that you are inappropriately doing things on behalf of the institution, then the disclaimer can really help you out quite a bit. Certainly, you want a disclaimer if you're like signing a petition or an open letter. Anything that you're actually listing your affiliation for on a political or politically adjacent item, a disclaimer is really very valuable.
Thank you. The next question says, thanks for the presentation. Can you speak a little more about personal advocacy on topics related to our federally funded research? For example, is it inappropriate for climate scientists to be personally involved with climate policy action groups? Advocacy groups, excuse me.
So this is a question that we asked our lawyers about, actually, and their answer was twofold. One, if you're, for example, a dendrochronologist and you're looking at historical temperature records and your advocacy relates to carbon taxes, that's totally fine. If you actually study carbon taxes and your advocacy is related to carbon taxes, then that gets trickier, and that's where you want to make it very, very clear that you're doing so as a private citizen, and you want to be extra careful to do things like make sure if you call your congressperson that you do not do it from your work phone. Making very clear that you're doing so in your private capacity. With the stuff that it's already pretty clear that it's not related to your professional role, you can be a little more casual about it. It still is a better idea not to commingle work and private stuff, but when you get to the area where it pretty clearly overlaps with your work, I think is where you need to be extra conscientious about not using anything federally funded, your work computer, your work phone, doing it not doing it on work hours, etc.
Thank you. Our next question is, how do I find out what the lobbying rules are for my institution? And what if I'm affiliated with multiple institutions?
So that's a good question. If you get federal funding related to a specific agency, the agency should put out guidance documents. Some of them are better than others. For example, I know NOAA has a pretty decent one. NIH has a really good one, probably because people in the medical industry run into this issue a lot. So first I would start with whatever agency is giving the funding. When it comes to the actual institution, they're all over the place. Sometimes it might be in the handbook. Sometimes it might not be so obvious, in which case I would recommend talking to your supervisor. You can also always contact us and we can try and parse it out. We have definitely helped people understand the specific rules that apply to them because admittedly it is not always clear.
Thank you. The last question we have right now is, can you tell us more about what is in those booklet resources that you mentioned?
Sure.
Go back. Yeah, let's try to go back to the. Yeah, we have a number. So we've developed a couple different guides, booklets, handbooks, and we have more in the works. So those you can actually see quite a few here. So for example, we have a handbook pocket. We call it a pocket guide because we try to keep these short and pretty usable. That is intended to help scientists deal with situations where they are facing harassment and legal intimidation, and sort of sets out how to, best steps for handling various kinds of harassment that we know scientists frequently encounter. We also have a guide on participating in advocacy and protests specifically, which sort of as an example, a lot of people got involved in the March for Science and really felt compelled to go participate in similar protests and marches. And so we have a guide that deals really specifically with your rights when participating in such an event, and what to do, for example, if you're encountering the police, things like that. We have a guide to writing open letters for scientists, which is more sort of a one-pager, pretty quick, but
it has
helpful.
multiple disclaimer language examples if anyone's interested.
Yes. And then the last one is one that we worked on before I came on board, but we worked with Union Concerned Scientists.
Yeah, and a number of other groups. Basically, if you're a federally employed or federally funded scientist and you notice shenanigans, ways in which to document that with hopefully minimal risk to yourself. So those are just 4 that we fit on the slide. We also have a number more. We have a large piece on state open records laws, which we didn't talk about here, but they're certainly a common way that researchers at state-funded institutions, especially public universities, have been targeted. And as Augusta said, we have a number of resources coming out. We'll have a specific guide on anti-lobbying coming out shortly. I hope that we'll have printed copies in advance of AGU the week. So one thing I should mention is we will be in the exhibit hall. If you can't make it to our events, you could always come to the exhibit hall and pick up printed copies of any of these, plus this anti-lobbying guide that we are putting finishing touches on. And we have a number of other guides coming out in the near future. So stay tuned. Please, if you're interested in what we're doing and our resources, you can go to our website and sign up for our mailing list. We send out a monthly newsletter, which includes our upcoming events and our newest publications, webinars, events, things like that, that we are doing to hopefully keep scientists educated and reduce the number of legal incidents out there, because, it is a thing. We hope that no one on this call is unlucky enough to experience that, but if you do, again, please just call us. We are here for exactly that reason, to help scientists navigate these issues.
Thanks so much. There are no more questions at this point. So I'll just say I hope that those who have been on the webinar, if they are interested in sharing this with anyone else, will share the recorded version. Feel free to come back and watch any parts of it later on if you want a review. And as Lauren and Augusta mentioned, CSLDF will have a strong presence at the AGU Fall Meeting this year in Washington, D.C. So come to our events, come see them at their booth in the exhibit hall. You can always check out the CSLDF website for more information. And we do have past webinars from this collaboration that are archived on the AGU Science Policy website. So with that, I'll say thank you so much, everyone, for joining us, and we'll wrap up.